Calling case number 88-3451, John H. Peabody and Citizens Right of the Way in the Bay Committee versus the Miles Standish Trust and John D.M. Good appellant. May we see the appellant, please?
Good afternoon, Your Honors. My name is Dru Keegan, representing the appellant, John Good. I would like to reserve a short amount of time for my rebuttal. It is our contention that Rule 11 sanctions should not be imposed upon an attorney for removal when a federal question is presented by the plaintiff. The district court's award of $10,000 attorney's fees was inappropriate because a competent attorney could have reasonably concluded federal subject matter jurisdiction existed. And the district court's order to suspend was inappropriate because Mr. Good's actions did not constitute bad faith. Rule 11 sanctions were imposed in error because Mr. Good was reasonable in determining the case was removable to federal court. The appellees sought relief under the right to access by virtue of navigational servitude and relied solely upon federal cases in their motion for summary judgment. And actions relating to navigable waters have
Counsel, this was navigable waters. Were these navigable waters before and after the motion for summary judgment?
Yes, they were.
Why wasn't there a removal action before?
Because it was not clear whether the appellees were presenting a federal question in their complaint.
Well, at least in one of the grounds, they talked about a third-party beneficiary notion based on a dredging permit. That had at least something to do with federal grounds.
They were couching that term in state law. And the other basis for relief was vague. It rested on the common law, and it was unclear to my client whether they were asserting a federal question or whether they were relying solely on state law.
Well, it was that unclear, and there were 2 years of discovery, although this may be going beyond the gist of this particular action. Couldn't have been discovered far earlier by some kind of motion as to whether or not there was a case based on federal right, because all it has in the original complaint is this statement, both as a matter of common law and as the intended beneficiaries of the terms and conditions of DA Permit 969. Isn't that at least ambiguous?
Yes, it is ambiguous. And that's why my client was unsure whether he should move to the federal court until it was clarified in the appellee's motion for summary judgment that they were relying on federal cases and federal law, and a federal question was indeed presented.
So you're saying it's absolutely clear because of the use of 2 federal cases alone?
Yes, it changed the nature. When the appellees relied on the federal cases in their motion for summary judgment, it substantially changed the nature of their claims.
Why?
And it was clear to my client that they were relying on federal cases, and it was a federal question of navigational servitude.
Well, if federal cases are used by way of analogy in a state court, does that make it a federal case?
No, yet still it was unclear to my client until they did rely on the federal cases whether they were couching it solely in state law terms.
Well, what I'm asking is what in the cases made your client think that this became a federal cause of action? What I'm going to get at, as you may understand, I hope, is that it's our understanding from the other side's notion that the use of the cases was purely to show that there was not a taking, not to go off on the issue of navigable water, and to show there's not a taking is not going to make it a federal case.
Well, it's our contention that it was not just a defense to our defense, why he quoted the 2 federal cases, but he quoted Kaiser to show what the courts are doing with navigable waters. And he was relying on federal cases in the motion for summary judgment so that he would, of course, win the case.
Would you call that malpractice?
On whose part?
On his part. To get it all of a sudden into federal action, it does seem strange that if this was based on state law in the eyes of the plaintiff, all of a sudden a federal case is used to indicate that these are navigable waters, when there are clearly some other grounds indicating that, based on common law, these are navigable waters.
Yes, that could be. But what we're claiming is that the original complaint was artfully pled to defeat removal. Now, whether that's malpractice or just a trial attorney's trick to keep it in state court, I'm not sure.
Thank you.
So Congress has held that to regulate the use of navigable waters, it's been decided that this power is supreme over the state's courts' rights. In Bel Air, Benwood, and Wheeling, it was stated that if these allegations are presented in the complaint, it makes no difference that other questions of general law are also presented. A complaint artfully pled to defeat federal jurisdiction may be recharacterized as one arising under federal law so as to permit removal to the federal court. And in Stokes versus Bechtel, it was held that a trial court judge will evaluate the language of a complaint to determine whether the plaintiff is omitting from his claim essential federal law or has cast in state law terms a claim that can be made only under federal law. And the court
this is a claim that it's not one that has to be made only under federal law. Am I correct that there is a state law right to use navigable waters?
Yes.
So a
They are
case
concurrent
so
powers.
a case that could be made only under federal law is inapposite to this situation, because this is a case that could be made under state law.
Correct, but if a federal question is presented in the plaintiff's complaint, then my client did have the right to remove to a federal court.
And the basis for you arguing a federal question is presented is strictly the fact that they cited this Aetna case.
The argument is that they clarified in their motion for summary judgment that they were presenting a federal question of navigational servitude, and this created the right for my client to remove to federal court.
Well, isn't the cite to this case equally consistent with using this case to destroy your taking defense?
No, I don't think so, because they, in their second cause of action, it was vague, and they were trying to defeat removal to the federal court. And their cause of action did rely on a federal question, but they tried to couch it in state law terms or to be vague to defeat the removal to federal court.
But you agree, though, that this case can also be relevant to the question of whether or not there's been an unconstitutional taking.
Yes, it could be relevant in that respect also.
And perhaps even more appropriately, it could be used for that, because that was the main issue in the case, wasn't it?
The main issue in the case is that they were trying to seek access to the Mockingbird Lagoon.
No, I mean in the Aetna case.
Pardon me?
In the Kaiser Aetna case.
In the Kaiser Aetna case?
Yeah, wasn't the issue in that case whether or not this was an unconstitutional taking without compensation?
Yes, but by citing Kaiser, the plaintiffs did change the nature of the complaint from state to federal law terms, because in their complaint they asserted common law as a basis for relief, and it was unclear whether they were asserting a federal question or whether they were asserting a term that could only be used in state law.
But in response to their assertion that they had a common law right, you responded that if they have that right, it would be an unconstitutional taking if you weren't paid for it.
Right.
And then in response to that, don't they cite the Kaiser Aetna case to show that this is not an unconstitutional taking?
Yes, I'm sure Peabody will claim that Kaiser cited to rebut the federal taking defense that we had of the eminent domain.
Yeah, and if that's the purpose for citing this case, then that does not create a case arising under federal law. We agree on that, don't we?
I agree that Peabody will claim that Kaiser was cited as a defense to the taking clause of the Constitution, but once they did clear up what they meant by common law, by using those two cases, it became clear to my client, or at least it was reasonable for him to believe that he could remove on the basis of Peabody citing those two cases in the motion for summary judgment.
I mean, if they want to meet your taking defense, you're not arguing that they can't use this case without submitting themselves to federal jurisdiction, are you? I mean, they don't have to forego citing the Kaiser case. And as soon as they cite it, then could you automatically say, all right, this case can be removed because you're obviously bringing a case arising under federal law? I mean, that's not correct, is it? I mean, they're entitled to use this case
right,
to rebut your taking defense.
Right, in a motion for summary judgment. Yet my client is entitled to removed to a federal court when he reasonably believed a federal question was presented in the motion for summary judgment. And the issue here is not whether they were solely using those as a defense, but whether there was a federal question presented in their complaint that was clarified by the motion for summary judgment, which gave my client the right to remove to federal court.
Well, the original complaint was ambiguous, you contend.
Yes.
Yeah.
The second cause of action was ambiguous.
This
First
citation,
cause of action stated rights as beneficiaries of the Corps of Engineer dredging permit.
But you didn't remove at that time, so
No, we
any
didn't.
right to remove with respect to that aspect of the case is gone.
It was vague and fearful of being sanctioned, since my client had been sanctioned before. This is one of the chilling effects of Rule 11. He waited until it was clarified in the motion for summary judgment. But since my client had been sanctioned by the court previously, he was not about to take any chances. And this is just one example of how Rule 11 can have a chilling effect on an attorney's representing a client's position.
Oh, okay. Well, let me pursue this just a little bit further. If at the time the complaint was filed, it was ambiguous, could you remove it at that time?
I'm sorry, would you repeat
Could you have
the
removed the
question?
complaint at the time it was filed on the basis that it was ambiguous?
Could he removed at the time that the complaint was filed?
Yes.
When it was ambiguous?
Yeah, based on the argument that
At the risk
it's
of
ambiguous.
running sanctions by the court, because there wasn't a federal question presented at that time. It was so vague.
But
That certainly they would have remanded it back to state court at that time.
Well, the citation to the Kaiser Aetna case is also ambiguous, because it could be a citation with respect to your taking defense, or it could be a citation with respect to the creation of a federal navigational right.
Right.
If we can't tell which it is, isn't the situation just as ambiguous as the complaint was at the beginning?
Yes, it was still ambiguous, yet under Rule 11, you only have to be reasonable in your belief, and Mr. Good reasonably believed this created the right to remove, believing that this clarified their claims and therefore presented a federal question. And as long as my client was reasonable, he did not violate Rule 11. And it must also be noted that every reasonable doubt is to be resolved in favor of the accused, and that Rule 11 is intended to accommodate the realities of law practice and not impose unduly unrealistic burdens upon investigative counsel.
You mentioned you wanted to reserve some time.
Yes.
Okay.
Okay, thank you, counsel.
Pardon? Sure.
Good afternoon, Your Honor. My name is Marie Bechtel. I am representing John Peabody and Citizens Right-of-Way in the Bay Committee, the plaintiffs and appellees. The issues today in front of us are whether or not sanctions were justly placed on Mr. Good's behavior when he unreasonably removed the case before us to federal court 2 weeks before the trial date in state court. Mr. Good has stated that he had reasonable belief that the case was a federal jurisdiction case. However, it's very plain that our position was a state position rather than a federal position. We, as the plaintiffs, have a right to